In today's courtroom drama, what started as a routine day at the Greenwood County Magistrate Court quickly turned into a tense face-off between a judge and a prosecutor. What you're about to witness isn't fiction. It's real footage from Kansas, where Judge Phyllis Webster confronted County Attorney Jill Gillette over a procedural error that could change both their careers. Before we dive in, don't forget to subscribe and leave a comment with your opinion. Do you think a prosecutor should ever be immune from a judge's authority? You might rethink your answer after this. Now, let's get into what really happened inside that courtroom.
We have to brought a copy up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here? He was taken off the docket. And what did I do? Mix up Tanya Richardson and Sanchez?
Mm-hmm.
And no one mentioned that I was using the wrong name?
You were using the right name.
Mm-hmm.
Oh, okay. Okay. Well, and these are my couple that I don't have anything filed to show that they have to be in court. I don't have a summons. I don't have a uniform notice to appear issued by the officer in the ticket.
Judge, the girls filed the ticket earlier today.
Okay, let me see if it's, maybe I just need to double check. Mr. Caldwell.
Mm-hmm. Tickets were issued January 23rd, 25 at 20:59 hours. But
Okay,
today,
well, let me make sure they made it to the file because I'm not seeing that. I don't see that, Ms. Gillette, and until I have filed verification that they had noticed this hearing. I'm not finding that. You're sure they filed them?
Arlene was the one who did it for us.
No, Missy, do you have that where you can look at it? Because I am not seeing it filed. Maybe I need to. No, I think I've already refreshed to see if they've been added. If you want to
They're
check.
not in the case yet.
What was that, Missy?
I said they're not showing up in the case yet.
I don't know if upstairs hasn't approved them or what's going on.
I can check.
Would you check? We'll take just a real quick recess because I don't have anything in the file to show they have notice of the hearing, so I can't take any action for their failure to appear without it.
You do. Arlene's going to bring the unfiled copy upstairs, Your Honor, but they were submitted this morning by Jessica.
Well, I need the originals. You're thinking the originals are on file somewhere or waiting to be filed? See what Missy finds. Maybe they'll find the originals at the clerk.
What, Judge? I'm sorry, I'm back now.
Well, she said they'll bring up, if I understood Miss Gillette right, they're bringing up copies, but where are the originals?
I think I actually have a copy because I was asking them today about it. So
Well, I
can print you off the copies that I got sent.
copies. I need original documentation that these people had notice of this hearing, either in the form of a returned summons or a citation. And I don't have anything to show that they know about this hearing today.
Your Honor, the citations, we get a Xerox of them. We don't get the originals. The originals normally stay either in the file with the sheriff's office now, or they go straight upstairs. But this had to be long formed because it's marijuana. And so
Well, even with the long form, I would accept, you don't have the originals, Arlene? What do you have? You have copies? Have those been filed with the clerk?
Yes.
They have been filed. They didn't make it into their file. Do you know why? I don't have them in the file.
Well, because that's the clerks.
Okay. Well, Missy, did you check with the clerks?
Yes, I just checked with them and they do not have them. They're not in the queue to approve.
I know they're not in the queue. I looked through the queue. Oh, unless you mean their queue.
Yeah,
Well, what I'm going to do, now I'm looking at copies of tickets, and I've seen enough tickets over the years to know these are tickets, and they are They do appear to be signed by the signature I know as Blake Fisher's, although I'm not an expert in handwriting.
It all began when Judge Webster noticed that several defendants had failed to appear for their scheduled hearings. Normally, this would be a simple matter. A bench warrant could be issued for their arrest. But there was one major problem. There was no evidence that those defendants were properly notified of their court dates. Under Section 19-4739 of the Kansas statutes, a judge can only issue a bench warrant if the defendant fails to appear after receiving official notice. Without proof of that, Judge Webster's hands were tied. When she pointed this out, implying that the county attorney's office had failed to properly file the documents, things got personal.
But I am not comfortable issuing any kind of failure to appear warrants if there's no documentation in the file. These are just handed to me, but once they are filed, then I would not hesitate to issue warrants for their failures to appear. So I'm going to set these two cases over till next Tuesday. By then, I'm sure that we'll figure out why those haven't been filed. And then if they're not here at that date and time, we'll issue warrants. But they'll have to be given notice of the new date and time. And it looks like they're out of Wichita, Kansas. Yes, so.
If I have to issue new summonses, then it's going to be more than a week because I have to issue them, send them to Wichita, and have them served on them. They have their notices to appear, complaints.
All right, I'll tell you what. I don't
even get the original anymore.
Just file the copies, whatever, but they have to be filed, Ms. Gillette. I have nothing that gives me legal authority to issue failure to appear warrants. I have in the file, and I'm looking at it, a complaint, a probable cause affidavit, a notice that you're going to rely on KBI reports, and that's it. There is nothing in the file to show legally that they have notice of this hearing. So I don't know where the tickets are. I don't know why they're not filed.
County Attorney Jill Gillette didn't take the criticism lightly. In front of everyone, she fired back, claiming that prosecutors were immune from being held in contempt. Judge Webster immediately corrected her. She reminded Ms. Gillette that even prosecutors are subject to ethical obligations and judicial respect, referencing the historic Imler v. Pachtman 1976 decision, which grants prosecutors immunity from civil lawsuits, not from courtroom discipline. This moment shifted the entire tone of the courtroom. What had started as a procedural discussion turned into a rare public clash between two powerful figures of the justice system.
I understand that someone in your office said they gave them to the clerk. I understand the clerk to say they don't have them. I don't know where they are, but I do not have them, so I cannot issue any kind of warrant for failure to appear. So, in fact, if you find them and get them in there even today, we can deal with it today rather than trying to issue summonses. But get me something I can legally use. Otherwise, get me something I can legally use. Otherwise,
I'll call Sheriff Samuels and ask him if he can bring the originals out of his file.
I'm not telling you have to do the originals. I'm just telling you, Miss Gillette, I cannot legally issue a warrant. And you know that. You know I have to have verification before I issue a warrant.
And we emailed them to your staff who has them this morning. They were sent to
my secretary is not the clerk of the district court. My secretary is not the custodian for them. They have to be filed.
Up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here? I am not going to accept your behavior. You're putting me in a position where I'm going to have to find you in contempt of court if you're going to act like this.
I don't have the original, Judge. I can't get it to you. We filed them this morning. That's all I can tell you.
Ms.
We
Gillette, you are not listening to me. And you're being contemptuous.
Judge Webster cited Section 20-1203 of the Kansas statutes, which allows judges to punish direct contempt, defined as contempts committed in the presence of the court. In plain words, it means if you disrespect a judge to their face, you can be held in contempt. No exceptions, not even if you're a prosecutor. Historically, this principle has existed for over a century. In fact, in the 1877 case of In re Pryor, the Kansas Supreme Court ruled that an attorney can be punished for insulting or disrespectful language or conduct in the presence of the court. As Judge Webster reminded Ms. Gillette, being a prosecutor doesn't make you untouchable. Respect for the court is not optional. It's part of your oath.
The state has contempt immunity. We already briefed this. If you would like us to get them filed again, we will
You
file.
have contempt immunity? Do you have ethical immunity that you can talk to a judge any way you want and have no repercussions? Is this what you're saying?
I will find the originals, whoever has them, and we'll see if we can get them to you. We will get them filed.
And we will finish this later, Ms. Gillette. At this time, Missy, it looks like Ms. Gillette has decided to remove herself from the hearing. As I said, this matter is not over and it will not be tolerated. But for now, we will be in recess.
The tension was undeniable, but what happened next showed the true meaning of professionalism. Despite the heated words, Judge Webster didn't let emotion take over. She refused to issue warrants she didn't have the legal right to sign and stayed firm on her duty to the law. Ms. Gillette, on the other hand, faced a tough realization. Immunity doesn't mean impunity. Prosecutors, like everyone else, are accountable for their actions inside the courtroom. According to Rule 3.5D of the Kansas Rules of Professional Conduct, attorneys must not engage in undignified or discourteous conduct degrading to a tribunal. And that's exactly the principle Judge Webster defended, the dignity of the court.
I understand that someone in your office said they gave them to the clerk. I understand the clerk to say they don't have them. I don't know where they are, but I do not have them, so I cannot issue any kind of warrant for failure to appear. So, in fact, if you find them and get them in there even today, we can deal with it today rather than trying to issue summonses. But get me something I can legally use. Otherwise,
I'll call Sheriff Samuels and ask him if he can bring the originals out of his file.
I'm not telling you have to do the originals. I'm just telling you, Miss Gillette, I cannot legally issue a warrant. And you know that. You know I have to have verification before I issue a warrant.
And we emailed them to your staff who has them this morning. They were sent to
My secretary is not the clerk of the district court. My secretary is not the custodian for that. They have to be filed.
Up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here? I am not going to accept your behavior. You're putting me in a position where I'm going to have to find you in contempt of court if you're going to act like this.
I don't have the original, Judge. I can't get it to you. We filed them this morning. That's all I can tell you.
Ms. Gillette, you are not listening to me. And you're being contemptuous.
The state has contempt immunity. We already briefed this. If you would like us to get them filed again, we will file.
You have contempt immunity? Do you have ethical immunity that you can talk to a judge any way you want and have no repercussions? Is this what you're saying?
I will find the originals, whoever has them, and we'll see if we can get them to you. We will get them filed.
And we will finish this later, Ms. Gillette. At this time, Missy, it looks like Ms. Gillette has decided to remove herself from the hearing. As I said, this matter is not over and it will not be tolerated. But for now, we will be in recess.
In the end, this courtroom confrontation wasn't just about paperwork or a missed filing. It was about principle. What we witnessed in Greenwood County wasn't a heated argument between two professionals. It was a moment that exposed a deeper truth about the justice system. Power means nothing without accountability. From the very beginning, Judge Phyllis Webster did what every judge should do. She followed the law, not her emotions. When she realized that several defendants hadn't appeared for their hearings, she could have simply issued bench warrants and moved on. That's what most people would expect. But Judge Webster noticed something crucial. There was no legal proof that those individuals had even been properly notified to appear in court. And according to Section 19-4739 of the Kansas statutes, a judge cannot issue a warrant without proof of notice. That small detail, that missing document, was enough for Judge Webster to stand her ground. She refused to punish citizens unless the process was done correctly. That is what separates a reaction from justice. When she pointed out this procedural error, County Attorney Jill Gillette took it personally. Instead of acknowledging the oversight, she challenged the judge, claiming prosecutors were immune from contempt. But Judge Webster's answer was a masterclass in judicial authority. Calm, direct, and factual, she reminded everyone in that courtroom that no one is above respect. She cited Section 20-1203 of the Kansas statutes, which grants judges the power to punish direct contempt, meaning any disrespect shown in their presence. No title, no position, and no degree exempts someone from that rule. And she didn't stop there. Judge Webster also referenced the 1877 case of In Re Prior, which established that even attorneys can be punished for insulting or disrespectful behavior toward the court. She reminded Ms. Gillette and everyone watching that being a prosecutor doesn't mean being untouchable. This wasn't a clash of egos. It was a reminder that the law doesn't bend for anyone. Judge Webster demonstrated what judicial integrity truly looks like. She refused to act without lawful authority, even when it would have been easier to sign the warrants and move on. She upheld the rule of law, defended the dignity of her position, and, most importantly, refused to let emotion replace ethics. And while Ms. Gillette's reaction might have been impulsive, we've all been there, frustrated, exhausted, or under pressure. One outburst doesn't define her entire career, but it does remind us that even those who represent justice are still human, and that humility, above all, is what keeps the system balanced. In the end, no sanctions were issued. Both women returned to court, working together again on good terms. But what stayed behind was a powerful lesson, one that echoes beyond that small Kansas courtroom. Respect is not optional. It's the foundation that keeps the entire judicial system from collapsing. Judge Phyllis Webster didn't just enforce the law, she embodied it. Her actions proved that fairness isn't about authority, it's about responsibility. And that's what separates a judge who rules from a judge who leads. So, what do you think? Was Judge Webster right to hold her ground, or should she have been more lenient with the prosecutor? Drop your thoughts in the comments. I read every single one. And if you believe that true justice begins with respect, make sure to like this video, subscribe, and share it with someone who needs to see how integrity still exists in the courtroom. Because at the end of the day, it's not the robe that gives the judge power, it's the courage to wear it right.